Hello and welcome to Legal Angle, the only show in India that caters to real estate legal problems and gives you a guaranteed solution. Dear viewers, it is said, we are born and then death is certain. So before death, we can predetermine the disposal of our wealth and make a will. Yes, you heard it right. No matter what age group you're of, this is an important factor, making a will. And to discuss on the same, we have a chartered accountant and also an entrepreneur of Vimal, Punmiya and Co. None other than Mr. Vimal Punmiya himself. Hello and welcome to the show, sir. As plain as it sounds, we all know we can create wealth. We can manage wealth. But when it comes to distribution of wealth, a big question mark. Can you tell our viewers, what is a will?
A will is the document in which person who make the will, he write how his asset is to be distributed after his death.
Okay.
You rightly said, once we are born, death is certain.
Correct.
But till I am there, I can control my wealth. I can do whatever I like.
Correct.
When I am not there in the world, how I want my whatever wealth I have, maybe inherited, maybe self-earned, how I want to distribute that wealth. And that wealth can be distributed by me in the will. For that purpose, I have to appoint one person known as executor. I will be not there at that time. Okay. Now, who will be there? Who will do all the exercise what I want? So that person to whom I appoint is known as executor. Then whom I want to give, they are known as a beneficiary. Okay. And under the will, if there is no will, then naturally law will apply, normal law, Hindu Succession Act or Muslim law or Christian law or Parsi law. If will is there, then it will go as per the will. And a very prominent case of a Bidla family in which one lady has given her wealth to the extent of 10,000 crore rupee to her chartered accountant, Mr. Loda.
Oh, okay.
That is different thing. These things were not there in luck of Mr. Loda, because before he inherited money, he himself passed away. Oh. So he went to his children. But under the will, asset can be given to any person of my choice. Okay. I can give to my children, I can give to my wife, I can give to my parents, I can give to my brother, I can give to my girlfriend, I can do whatever I like.
Whatever you like. Sir, no, you very rightly spoke about executor. So can you tell our viewers what exactly is an executor?
Executor is the person when I am not there, because will come in effect only after my death.
Correct, correct.
Till I am alive, I can do whatever I like. It is not that I made a will and given to somebody else. Okay. So in my lifetime, I cannot use the money. As for my lifetime, I can do whatever I like, I can sell, but do whatever I want. After my death, I appoint one executor in the will. That can be relative, that can be my children, that can be my friend, any person whom I have faith.
Dear viewers, an executor can be anyone. It could be your family member, it could be a relative, it could be either your husband, or it could be a wife, or it could be anybody who you have faith in is an executor. Carry on, sir.
Executor is the person who will look after my death.
Okay.
He will distribute the asset in the way in which I want. So executor need not be a relative, it can be a friend, it can be a bank, it can be an institution. Many Raja Maharajas have appointed many times Bank of Baroda, Bank of India, Central Bank as executor. Okay. But normally he should be the person of integrity, okay, and in whom I have confidence. For example, my children are minor. In my will, I have given assets to my children, say son and daughter who is say 10-year-old. Then I must have faith in the executor. He will distribute assets to my children when they become major. Okay. So executor can be any person, but many times it happens that I appoint Mr. A as executor, and before my death, his death take place.
Okay, yeah.
Then will be invalid. Then I have to make another will.
Another. So dear viewers, executor can be anybody whom you have faith on. It could be a husband, it could be a wife, it could be a children, it could be relatives, it could also be banks.
Yes.
You could also give it to the banks. So that takes us to my next question. How do we actually make a will?
Exactly. Now this is really good question. Now once we make a will, for example, I want to make my will.
Okay.
First, in one paragraph, I have to write my name, address, age,
okay,
so identify who I am.
Correct.
So after my death, somebody can find out whose will is this.
Correct.
Then my all movable and immovable property, which I have as on today, I must identify. Need not be with the figure. Okay. I may have 10 FDR or 1 lakh each. I don't have to give the figure of all 10 FDR. I can say FDR with bank. Okay. My balance with the bank account, loans and advances, shares and securities, jewelry. Like that, I must identify all my movable asset and all immovable asset. Okay. Then I must give name of my relatives. Who are my relative? So tomorrow my children should not say that when I made the will, I was not mentally of sound mind and I missed somebody. So I must write, I may give them asset or not, that is a different thing, but I must write name of my wife, my son, my daughter, my grandchildren. So I remember everyone when I make a will.
Correct.
So after writing their name and the relationship with them, I must appoint one executor. Okay, Mr. A is appointed as Mr. Executor, or there can be two executors, or I can say I appoint Mr. A as executor. In case he predeceases me, then B will be executor, and that can be any person I told you as.
Correct.
Then I must identify which asset will go to whom.
Correct.
After executor, I must give list of my movable property,
Correct.
list of immovable property, then whom I want to distribute. Now, for example, I want to distribute conditionally. I give everything to my wife, but in case my wife is not there, then son. If son is not there, then daughter-in-law. So I can make it very clear.
No, can we have multiple executors, or is it a rule that you need to have just one executor?
No, you can have number of executors.
You can have
a number of executors. And executor will, after my death, executor will have control of my asset, and as per my wish, he will distribute it.
Okay. So you've heard it, how to make a will. You need to list down all your family members so that you have not left out anyone, and you can keep one executor. You can have multiple executor, but the main executor has to be listed in the will.
Yes.
All
are to be listed in the will. If I want to appoint 10% executor, all should be listed in the will.
Okay, so if you're appointing multiple executors, you need to list them down in the will. Also, now we know how to make a will, but is there an average age to make a will?
As you rightly said in beginning, once we are born, death is certain.
Correct.
Sometimes you find 20-year-old person is no more, and 95-year person is also there.
Correct.
So there is no age, but normally after 50, one must make a will.
After 50, one must make a will.
Normally, I made my first will. I was just 30-year-old. I was going to USA. I went to my DM Harish to take his blessings. And his first question, he asked me, "Have you made your will?" I said, "I'm going to US of holidays." He said, "No, make your will and then go." And I made will at the age of 30.
On sets with Mr. Vimal Punmiya, we are having a very interesting conversation on making of a will. Please do not go back because you're going to miss a lot. Stay tuned. We're going to be back after a short break. The youth is just working, he's normal working, he's dependent on family. Can he also make a will? If he's just dependent, what would he make a will as? I mean,
if asset is not there, then what he will make? He say whatever he will earn, it will go like this.
Welcome back. On sets with a chartered accountant and entrepreneur of Vimal Punmiya and Co, none other than Mr. Vimal Punmiya. So sir, if a youth is just working, he's normal working, he's dependent on family, can he also make a will? If he's just dependent, what would he make a will as? I mean,
if asset is not there, then what he will make? He say whatever he will earn, it will go like this.
Correct.
And will can be changed. At the age of 30, I might have given everything to my wife. Today I want to give, my wife already have substantial wealth, so I want to give to my children. I want to give to somebody else. Today I may give to my wife, and tomorrow divorce take place. Automatically will come to an end. Today I have given everything to my parents, and after my marriage, that old will come to an end. So priority will change from time to time. So will can be changed. I will just give you a very interesting example. One person has 4 children. Majority of wealth is divided to 4 children. All have shops and flat. He kept 1 crore with him. And under the understanding, he stay 3 months with son 1, 3 months son 2, 3 months son 3, 3 months son 4. Now go and stay with son number 1. 3-4 days he will take care, and then he is after the will only. Okay, father will give 1 crore to whom? So they come to my office. I make will in name of first son. Then after 3 months he will go to second son. After 1 week, second son will be after let's say another will. So he comes to my office, change the will and make in favor of second one. Like that way, in last 5 years, he made nearly 30 wills.
30 wills?
So you can change every day whatever you like.
All right.
Recently, I've seen one will actually, one of my client, she was married at least 3 times. Like this was her 4th marriage. Husband also got married 4th time. And when I open her will after death, she has given 25% to the servant, 25% to a carpenter, 25% to a driver, 25% to an animal hospital. Nothing to children, nothing to husband. So it is a personal asset, personal wish, and you can do whatever you like, and you can change whenever you want.
So now you've mentioned about the person having 30 wills, like he's changed multiple times. So the last
will be prevailed.
The last will be prevailed. So not the first son, not the second son, not the third
last
son.
will.
The last will. So whoever makes a will, the last will that is seized with the court is the final will.
No, it can be found anywhere. I can keep in my cupboard. It must be preserved in such a way after my death, my executor find the will. So I must make 3-4 copy, give you 1 copy to all executors. And original also I can keep in a locker or keep in my chartered accountant or advocate. But many times it happens that will is not found after the death. So relative just assume that there is no will.
No will.
They distribute the asset as Hindu law or Muslim law or whatever law is applicable. And after 10 years they come to know there was a will. So normally, legally speaking, registration of will is not required. But it is better to register it. So anyone can go to registrar's office by paying some 100 rupee fees, they can take the certified copy.
It is better to register your will so that it is safe with the register. It is just safe. Alright, takes me to my next question. What kind of people are entitled to make a will?
all person who is of sound mind,
Okay.
not minor,
Okay.
can make a will.
Okay.
So any person of more than 18-year-old
Okay.
can make a will,
Okay.
provided he is of sound mind. But for example, somebody is not sound mind in the morning, but afternoon he is okay. Then in afternoon he make a will, it is valid will.
Okay. Like, can you give an example if a person who has no sound mind in the
Like for
morning
example,
and
somebody is in sun, he don't understand what he is doing.
Correct.
But in the morning hours, this problem is there. Afternoon he is all right.
His afternoon is all right. So
Or
he can
evening
make a
he is
will.
all right.
Okay. Okay.
So once it is proved that when he made a will,
Okay.
he understood what he is doing,
Okay.
then it is a fine.
So technically, anyone above the age of 18 with a sound mind can make a will.
Yes.
Do we need witnesses for the bill?
In will, 2 witnesses are required.
2.
Yeah, and a person who make a will,
Okay.
and both the witnesses must sign at the same time.
Okay.
It cannot happen that one witness sign at 4 o'clock and second witness sign at 6 o'clock. All must sign at same time, because any person who will challenge, they will challenge on only on this ground that witnesses were not there, one person has not signed at a time, witnesses were not knowing each other. So 2 witnesses, person who make a will, all must sit together and sign on one table at same time. And advisable to take one photograph also.
Advisable.
Because many times Raja Maharaja and a rich person, they make a will, lot of litigation takes place afterwards. So normally when we make a will, normally in big cases we take a video recording also at that point of time. So both witnesses is present and party is present, so nobody can dispute on that ground the person has not signed properly or he has not signed at all. So 2 witnesses, preferably if possible one doctor is there, it is good.
So viewers, we need 2 witnesses when you make a will. There has to be 2 witnesses. They both have to be present at the same time. They cannot be present at a different hour and another person at a different hour. They have to be present at the same time when you make a will. Preferably a photograph taken or a video recording would be a proof so that you are on the safer side that yes, the will is safe with both the witnesses around. Can a will be verbal?
Under Hindu law, verbal will is not permitted. In Muslim law, yes, but within few days they have to write, make it, the witnesses in whose presence the person make a will. In Muslim law, a completely different law. Person can make will only of his 1/3 of asset. 2/3 asset will go as per the Muslim law. And 1/3 asset also he can make orally. But the person witnesses in whose presence he said, they have to make in writing within 10 days.
So can you stress a little more on the Hindu law and the Muslim law?
Yeah, because you know, in our India, the number of laws are there.
Correct.
Christian law, Parsi law, Hindu law,
Correct,
Muslim
correct,
law.
correct.
And under Hindu law, whatever asset is there, I can distribute whatever I like.
Correct.
I already given you example of Bidla.
Correct.
Everything was given to a chartered accountant. I've given you example of that another lady
Correct.
who was given to a carpenter and servant. So under
Absolutely.
Hindu law it is allowed.
Yeah.
Under Muslim law, if person make a will,
Okay.
then he can distribute only 1/3 of his asset. 2/3 will go as per the Mohammedan law, and where higher right is there for the son and lower is for daughter, and as per that system.
Okay.
As far as Hindu law is concerned, will cannot be oral. But for example, person is dying, and in presence of 2 persons, he says, I want to distribute my movable asset like this. Immovable property has to be under the written will. Otherwise, it will go as per the Hindu law, equal to all legal heir.
Okay.
Wife, son, daughter, all are equal, which is not there in Muslim law. And under Hindu law, if for example I am dying, then I can say, okay, my FDR will go to so and so person, and 2 witnesses are there.
Okay.
And then movable property can be go, but within 10 days, my witnesses will make recording. Yeah, before my death, I said like this. But in army officer, oral will is permitted. For example, I am on the war, and at a time of my death, I make a statement before my 2 of my colleagues. Okay, I have following asset, and I want to distribute my asset like this. And my 2 colleagues make an affidavit within 10 days. Then oral will is possible. Otherwise,
Okay.
oral will for immovable property is impossible.
Is impossible. All right. So now we know that a verbal will is definitely not possible when it comes to Hindu law. Hindu law has to be written. And when it comes to Muslim law, yes, verbal law is possible, but only 1/3 of the assets. On sets with Mr. Vimal Punmiya, we are having a very interesting conversation on making of a will. Please do not go back because you're going to miss a lot. Stay tuned. We're going to be back after a short break. He doesn't understand the terminologies when it comes to a will. Like for example, what is codicil? And what is codicil in depth?
Actually, for example, I made a will today, and let us assume I have 2 sons.
Welcome back on sets with the chartered accountant and entrepreneur of Vimal Punmiya and Co, none other than Mr. Vimal Punmiya. You know, there are certain terminologies, you know, sometimes our viewers are confused. So in fact, you know, we had a very interesting question. You know, this show has been taking over 2 miles and it has been helping a lot of our viewers. So one of the viewers, Mr. Boniface Nazareth from Malad, you know, he doesn't understand the terminologies when it comes to a will. Like, for example, what is codicil? And what is codicil in depth?
Actually, for example, I made a will today. And let us assume I have two sons. I have given one house to each. Now later on I sell one of the house in my lifetime. So son to whom I have given the house, he will not get it.
Correct.
So I have one option, either to make another will completely, but I don't want to disturb my other adjustment or other distribution. Only one item will change. Then I can make a codicil, which is really amendment to the will.
Okay.
So I will just say I made a will on this day, registered or not registered, I will write that, and I will say this was the property disposed of by me. So I want to distribute the following asset to my this particular son. So to that extent, will is amended. For example, earlier I had 2 flats. Now I have 3 flats. And I want to give third flat to somebody else, or to my one son or second son, or my daughter. Then I can make an amendment to the will, which is a technical term, it's known as a codicil. Codicil also has to be signed in presence of 2 persons, 2 witnesses. If my original will is registered, then codicil also has to be registered. But it is a supplement to the will. So the codicil will be attached to the main will, so they become continuation of the will.
Okay.
So whenever I want to change the will, I have option either to make a new will or just amend it.
Okay, wonderful. So we have made the term very easy. Mr. Boniface Nazareth, if you're viewing the channel right now, codicil is just going to be a supplement to your will. It is just going to be an amendment to your will that is already present. Like, for example, if you are having 2 flats, 2 properties, and you have a third property which is not listed and you do not have any idea whom you have to give it to, you can then apply for the codicil, an amendment to another will that will be a supplement to your original will. So what are the other terminologies that are used? I mean, codicil was one that our viewers gave. According to you, what could be another terminology that...
Like a probate.
Probate. Okay, wonderful.
Now after the death,
okay,
all these 2 persons will distribute the asset.
Correct.
Now in case of a movable property, it can be distributed by delivery, by giving a possession of the property like jewelry or FDR, or it can be distributed via a nomination. For example, I have a flat in a cooperative society.
Correct.
And I have already filed, say under will I have given to my son. I also made a nomination in favor of my son, he will get it.
Correct.
Or for example, I have given to my son flat, but I made a nominee as a executor, I made you, then you will transfer to my son's name.
Okay.
But many times it happens, I have a immovable property which is not in a cooperative society. Like I have a bungalow, I have open land.
Okay.
I have a bank FDR where I am not made nomination with a bank, or FDR is not in joint name. It is exclusively in my name.
Okay.
Bank will not give money to my children on the basis of will. They will say go to the probate, have the will probated. Then I will apply to the High Court for the probate of the will.
Okay.
High Court will publish that will on the citation on the notice board for 45 days.
Okay.
If no objection is received, then I have to give consent of my other siblings,
Okay.
other legal heirs of the deceased.
Correct.
That there is no other dispute in the will.
Correct.
And then High Court will grant the probate. Probate means High Court will certify the will.
Correct.
Okay, yes, this is the correct. And based on that, all assets will be divided.
So, you know, you have used the word nomination, nominee, which itself is a vast topic.
Yes.
If we go through nominee itself. Sir, can you just summarize of what a nominee could be to our viewers?
Yeah. Nominee, you know, for I told you under the will, if nomination is not there, one has to go to probate.
Correct.
Now, probate will cost nearly ₹1,00,000.
Correct.
Stamp duty will be payable on that at the time of this High Court probate. Plus, there will be legal charges. So, I want to avoid that. Then wherever immovable property is there, or wherever FDR is there, like shares and securities, FDR with bank,
Correct.
National Savings Certificate, wherever nomination facility is available, I make a nomination. After my death, so-and-so person will be the nominee, automatically that institution will transfer in that name.
Okay.
Similarly, I have a flat in a society, or I have office in a society. Now what I will do, I will make a nomination with the society. I will just say I am holding flat number so-and-so,
Correct.
share certificate number so-and-so,
Correct.
and after my death, I want to give this flat to my son. So my son will be nominee. Or
Correct.
my wife will be nominee, or my wife and son both will be equal nominee.
Correct.
Or I want to give to my 3 children equally, or whatever way I
Equally.
want.
Correct.
And then nomination can be.
No, but this is listed in the will.
No, nomination is a separate thing.
It's a separate thing.
Nominee mein I am not giving asset to the person. I am appointing a trustee, executor.
Okay.
Now, for example, let us take a situation. I have one flat. I want to give to my wife.
Okay.
Now, if I make a will and give to my wife, after my death, she will be absolute owner of the property.
Okay.
Now, let us take a situation. I am not aware of the will provision. I feel I make a nomination with the society and my wife will get the flat. So, I file nomination form with the society. After my death, society will transfer in name of my wife. After my death, my wife will go to the society, make an application form, give copy of the death certificate, make an indemnity bond, and society will transfer in her name. But she is not the owner. She is simply a trustee. Let us assume that she sell the flat after my death.
Okay.
She will able to sell because her name is there in society
Correct.
record. Let us assume that she sell flat for 3 crore rupee and she get 3 crore rupee. But she will not able to keep the money. In case I have one son and one daughter, one third she will able to keep, one third will go to my son, one third will go to
So
my
it will be
daughter.
equally distributed.
Because she is the executor only. She is the nominee.
She's
She is
not
the
the
trustee.
owner.
But if I make will in her favor, then she is the 100% owner of the property. My son and my daughter cannot interfere.
Wonderful.
So under the will, I give the asset. Under the nomination, I appoint a trustee.
Viewers, when you make a will, it is just to that person. So the person gets that share. The person is the owner. But if you make a nomination, the person doesn't become an owner, the person is a trustee. So he gets a part and then it's distributed. Mr. Vimal, at this hour, I would like to thank you for being a
My
part
pleasure.
of our show and spending your time here with us on sets. Well, our viewers, we here at Spin TV and Legal Angle as a team are together to make you reach your destination in a smoother and nicer way in the real estate market of Mumbai. Stay tuned on Spin TV for more.